Ms. Sylvia Lim.
Mr. Speaker, I would like to seek some clarifications on this urgent bill, particularly on Clause 2 and to the amendments to Part 8C of the Act. First, on Clause 2. Clause 2 extends the validity of Parts 1 and 2 of the Act for another year to 19 April next year. These parts were enacted to enable parties to apply for temporary relief from fulfilling contractual obligations affected by the pandemic. The proposed extension is a recognition of the ground reality that there are still many businesses and individuals which continue to suffer adverse impacts from COVID-19. I note that the government has decided, however, not to extend Part 3, which provides for temporary relief for financially distressed individuals and entities. To recap, Part 3 had, among other things, raised the threshold for individual bankruptcy and corporate winding up from a debt of 15,000 to 60,000 and 100,000 respectively. It had also increased the time period to pay from 3 weeks from demand to 6 months. This bill confirms that the provisions of Part 3 will end on 19 April this year as scheduled. Yet today, we still see individuals and businesses who are drastically affected by the COVID-19 restrictions from earning income to pay their bills. These include our residents who used to run excursion and catering businesses, who have so far been unable to pivot to other business models. As we inch towards economic recovery, COVID support programs are being scaled down or stopped. However, economic recovery has been uneven across sectors. On this note, it would be most useful for the government to explain why it decided that there was no need to extend Part 3 of the Act to give individuals and businesses continued breathing space from insolvency proceedings. Next, I move to the amendments to Part 8C of the Act. Part 8C deals with the extension of the delivery date of property under sale and purchase agreements. The rationale for Part 8C remains sound. It enables developers, HDB, and the Jurong Town Corporation to have more time to complete construction projects delayed by the pandemic. It also enables purchasers of units to claim additional costs incurred by the delays, such as the cost of alternative accommodation. Part 8C was enacted into law by Parliament in November last year under the COVID-19 Temporary Measures Amendment No. 3 Bill. From what I understand, Part C has not come into operation yet, and I believe earlier the Minister of State did say it would be operational in a few months' time. I wonder why this is so, since the amendments in November last year were brought to the House on a certificate of urgency. In comparison, the amendments relating to Trace Together were brought to Parliament only in February this year and are already in force. In addition, could the Minister explain why the amendments to Part 8C are being made even before the provisions become operational? I recall that at the November sitting, the Minister had assured members that those provisions were drafted after wide consultations with the industry and were supported by the industry associations. Next, I wish to make two observations about Clause 8 of the bill. I particularly welcome the new Section 39(0)(a), which provides for a subsequent determination by an assessor based on new information. This is an important avenue to correct any injustice caused by an original determination, which has later proved to be unwise. Clause 8 also introduces a new Section 39(0)(b), which provides that parties coming for an assessment cannot be represented by an advocate and solicitor unless special permission is given. Such a no lawyers allowed clause is not novel and is present in other legislation that aim to provide low-cost and less formal dispute resolution mechanisms. Despite the good intention behind this no lawyers allowed rule, I wish to point out that experience has shown that this can inadvertently lead to unfairness. Residents who have gone through such hearings have highlighted to me that parties who are corporations have the advantage of sending their legally trained employees to represent the corporate entity, thus somewhat circumventing the no lawyers allowed rule. This has happened in the Employment Claims Tribunal and before FIDREC, the Financial Industry Dispute Resolution Center. Corporate employers and financial institutions send their in-house counsel who are not considered advocates and solicitors, while the employee or bank customer has to appear in his own capacity. This imbalance of knowledge and power has the potential to lead to an unjust outcome. For this bill, it is foreseeable that developers, HDB and the JTC will send legally trained employees to present their cases in front of assessors while the purchaser has to prepare his own case. I would like to ask if the assessors are alive to this risk of unfairness and how to address it. Thank you.